Okay, let's dive right into this explainer. If you are gearing up for your exams and need to master Section 11 of the Hindu Marriage Act, you are in the exact right place. We're going to set up some crystal clear signposts for void marriages so you can absolutely crush your exams. Consider this your definitive mental roadmap for conquering what can be a really dense legal topic. We're going to break it all down so you can easily recall these rules when you're under pressure.
We have 4 major signposts to hit today: defining void marriages, the notoriously tricky rules of filing petitions, legitimacy and inheritance rights, and finally, a rapid-fire look at landmark cases on bigamy.
Let's hit that first signpost. Section 1. Defining void marriages.
Grab your mental highlighter for this one: void ab initio. This is a golden phrase you definitely want to drop in your exam answers. It literally means that if a marriage breaks the mandatory conditions, it is void right out of the gate. We're not talking about a marriage that exists for a while and then, just gets canceled. Legally speaking, it simply never happened.
So what exactly are those mandatory conditions? Well, these are the specific Section 5 contraventions that'll trigger Section 11. We're looking at things like bigamy, meaning you already have a living spouse, or being within the prohibited degree of relationship. Then there is Sapinda relationships, where you share a close common ancestor, unless a specific custom permits it. Oh, and here is a crucial one. As the 2009 Sauriya Raja case laid out, a marriage between a Hindu and a non-Hindu is void per se under this specific act.
Moving right along to signpost number 2. Section 2, Rules of Filing Petitions.
Now, examiners absolutely love to set a trap right here. With the 1976 amendment, look at this stark before and after. Before 1976, one party could actually sue a deceased spouse. Yeah, you saw that in the old Lakshmana case. Talk about holding a grudge from beyond the grave, right? But after 1976, the door slams completely shut. Once the spouse passes away, no petition under Section 11 can be filed. Make sure you lock that timeline down.
And this brings us to the strict rule of standing. The statute explicitly mandates that a petition can only be presented by, quote, either party thereto against the other party. Basically, Section 11 is an exclusive VIP remedy only for the actual parties to the marriage. Nobody else gets to use it, which leads right into a massive limitation you will almost certainly see on your test.
We call this the first wife's dilemma. Say a husband takes a second wife. Can the first wife file a Section 11 petition to strike that second marriage down? Nope, she cannot. Because she isn't a party to that second marriage, the Kedar Nath case confirms she has absolutely zero standing under Section 11. Instead, her relief is found over in general law, specifically Section 34 of the Specific Relief Act. It's a procedural technicality for sure, but man, it is a vital one to memorize.
All right, signpost number 3, Section 3, Legitimacy and Inheritance Rights.
This raises a massive legal and, honestly, moral question. When a marriage is declared void ab initio, meaning the law says it never existed, what happens to the kids? Do they just lose all their inheritance rights entirely?
Thankfully, no. The really crucial point here is that both before and after the 1976 amendment, legitimacy is granted to the child of a void marriage. But it's a limited legitimacy, designed specifically so they can still inherit under Section 16. Now look at the old procedure. A formal decree of nullity, it was strictly required for the child to get that legitimacy. The 1976 amendment completely fixed that hurdle. Today, even without a formal decree of nullity, the child retains that limited legitimacy in the eyes of the law.
Now, let's solve a very specific inheritance puzzle. Generally speaking, in Hindu law, an agnate, so a relative traced entirely through males, is preferred over a cognate, which is traced through females. But Section 16 totally flips the script when it comes to void marriages. Because the child only has that limited legitimacy we just talked about, a cognate will actually get the property over an agnate in this specific scenario. It's wild. It fundamentally upends the usual family tree expectations, so definitely remember that flip for the exam.
Final signposts. Section 4, Landmark Cases on Bigamy. Let's hit a rapid-fire sequence of Supreme Court cases that are basically pure gold for your flashcards.
First up, the 1995 Sarla Mudgal case. Think of this as the precedent. It laid down the law that a Hindu man converting to another religion simply to take a second wife is still liable for criminal prosecution under Section 494 of the IPC. You can't just casually swap religions to find a loophole around bigamy laws.
Building directly on that, the Lilly-Thomas ruling in 2000 crystallized the principle. It famously declared that converting just to get married a second time is still bigamy, and that second marriage, absolutely void. The Supreme Court firmly stated you cannot exploit religion as a mere commodity just to get a divorce or bypass marriage laws. They swiftly shut down the audacity of even trying that.
Oh, and there is a highly testable nuance from that exact same Lilly-Thomas judgment regarding apostasy, which means abandoning your religion. The court noted that apostasy as a ground for divorce is available only for the innocent spouse who actually retained Hinduism. The one who converts, they can't use their own conversion to force a divorce on their partner. Which brings us to the 2011 case of Asiya Subhash Babu versus State of AP. This is the affirmation. It cemented the legal standing of the first Hindu wife. The court held that after a husband's conversion and second marriage, that Hindu first wife is entirely entitled to maintain a criminal complaint against him under Section 494 of the IPC. It firmly closed any lingering loopholes about the first wife pressing criminal charges in these scenarios.
So, here is my critical question for you. Are you ready to apply these Section 11 signposts to your exam scenarios? You've now got a structured blueprint covering everything from void ab initio to the flipped inheritance rules, all the way to those big bigamy cases. When the exam asks if a first wife can file a Section 11 petition, are you going to spot the trap? Will you remember the limited legitimacy rule? Review these signposts, stick to the roadmap, and you will absolutely crush it. Thanks for joining me on this explainer today, and I will see you in the next one.